Hey everybody, Mr. Moffin coming at you here with an APGov video taking a look at topic 3.13, affirmative action. Now, in this particular topic, in this video, we're going to be taking a look at the idea of affirmative action in terms of its origin, its goals, and the controversies that surround it to this day in terms of, trying to be able to guarantee equal protection of the law, but at the same time, making sure that, past discrimination and the effects really of past discrimination have been properly addressed. And that really does get us into what the real crux of the issue is. When we talk about equal protection of the law, when we talk about the idea of equality of opportunity, what does that look like? What does that mean? Is that simply legislation? You know what I mean? If, for example, we have the 14th Amendment Equal Protection Clause, if we have the Civil Rights Act, if we have, things like that, Title IX, for example, does equality of opportunity now exist because it has been legislated? Or does there need to be additional remedies applied due to the effects of the discrimination from the past? So the idea is kind of like this. Supporters of affirmative action, and note, affirmative action is the idea that there must be given extra opportunity for minority groups that had been traditionally discriminated against in society. So you're talking about people of color, you're talking about women, etc. But it's usually we look at people of color and women as groups that are going to be, looked at to benefit from affirmative action. And so the idea is that to make up for past discrimination, extra opportunities need to be created. And it kind of comes from this perspective. We know, there's no question that, people of color and women were historically discriminated against for generations in American history, and that meant that these groups did not have equal opportunities in education, in the business world, etc. So there's no question about that. But when we do start to see things like the Civil Rights Act be passed, the question then, or the concern that supporters of affirmative action have is that, well, starting from this point, the government is going to make sure that everybody's going to be treated equally. But supporters of affirmative action would argue, though, that coming into this spot, people of color and women are not at the same spot as white males. And so, in other words, you're saying we're going to treat everybody equal now, given one group already has tremendous built-in advantages from the legacy of discrimination. And so, moving forward, everyone now gets to move forward, but white males, in essence, having a head start. How do you alleviate that inherent head start and truly make it equal? That's what supporters of affirmative action would say is necessary to do that. And you do that, once again, through greater opportunities. Extra opportunities in hiring for jobs, extra opportunities when applying for colleges, things like that. So that's where this notion comes from. Now, if you are going to engage in affirmative action, and note, affirmative action starts to be a policy promoted by the federal government starting in the 1960s during the LBJ Great Society era. So it's a relatively modern concept, obviously coming in the wake of the civil rights movement. Now, once again, if the plan is to achieve, greater equity in reality via affirmative action, well, how do you do that? How do you make that happen? And the early attempts at it was to use a quota system to make these things happen. So, for example, if you are a college looking at admissions and you want to, use affirmative action to guarantee equal opportunity, you might look at the national population and go, okay, approximately 15% of the population is black, approximately 20% of the population is Latino, 50% of the population is female. Given those, breakdowns in the national population, a school might traditionally say, well, we're now from our admissions applications pool, we're going to guarantee that half of those students admitted are women, just guaranteed. And we're going to guarantee that 20% of those applicants, or 20% of those students admitted are Latino, and guarantee 15% are African American, using fixed racial and gender quotas to guarantee those things. So the idea, is sound in the sense that you're trying to come up with a guaranteed way to make sure that everybody, based on racial and gender lines, gets those equal opportunities. However, what about the idea of looking at people beyond simply from a racial and gender perspective? Is making decisions purely on those things a violation of the Constitution? And that brings us to the case of Bakke versus California. Alan Bakke was applying to the University of California Med School. And in the 1970s, that university was using a quota-based, affirmative action-inspired admissions process, like we just talked about, the use of fixed racial quotas. Now, Bakke does not get admitted to the school, but he claims in his lawsuit that based on other factors, such as, GPA, standardized test scores, recommendations, work experience, etc., that his qualifications were superior to the qualifications of minority students that were admitted. And, the basic argument that Bakke makes is that he was denied admissions to the school simply because he was a white male, claiming what we call reverse discrimination. The idea being is that this is a non-traditional example of discrimination, in this case, a white male. So Bakke, files a lawsuit on this issue, and the Supreme Court has to decide, is the use of first of all, is affirmative action in and of itself a violation of the Equal Protection Clause? And in this case, the court says, no, affirmative action is not a violation of the Equal Protection Clause. And here's the reason why. Some of you might be listening to this going, hold on a second, Mr. Maupin, you've mentioned previously about, the use of strict scrutiny when you're talking about discrimination based on race, and that any attempt to discriminate based on race is automatically assumed to be unconstitutional as far as the Supreme Court is concerned. And that's true. That is correct. But note, though, the court has said, though, that there can be very, very super important, compelling reasons to sometimes allow for racial discrimination. And according to the Supreme Court, this is one of those occasions, that the desire of a university to have racial diversity, for example, given the legacy of racial discrimination in the admissions process for universities, is so compelling and so important and so legitimate that the use of discriminating or making distinctions based on race via affirmative action is protected. However, the Bakke ruling says, though, that even though affirmative action is protected, you cannot use a fixed quota system to make that happen. So the court is basically telling schools and universities, you can, make distinctions based on applicants that include race, but you cannot do it in a fixed quota manner. So it does kind of, create a little bit more of a challenge that, hey, if you are trying to achieve, racial diversity, you have to come up with a method other than a fixed quota system. Which then brings us into the 21st century with some very recent cases affirming, regarding the constitutionality of affirmative action. With regards to hiring practices, not hiring, but admissions to colleges and universities. One of these is the case of Grutter versus Bollinger, which focuses in on the University of Michigan Law School. In this case, the University of Michigan Law School used what was a point system for admissions into their law school. So the idea being is that you had to earn X number of points in order to get into the law school, and you earned points from a number of various factors. You got so many points based on your GPA, so many points based on standardized test scores, so many points based on internship experience, so many points based on recommendations, blah, 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 blah. But you could also score points if you were a minority applicant, a racial minority applicant. And because of that, one of the applicants that did not get in filed a lawsuit claiming that the use of awarding points to racial minority applicants was a violation of the Equal Protection Clause, that it denied students like her the same opportunities to get in as anybody else. And the Supreme Court is going to agree that the use of that point system did violate the Equal Protection Clause. However, it didn't say anything about affirmative action in and of itself as a violation of the Equal Protection Clause, or the idea as to whether or not achieving racial diversity in schools is a legitimate, compelling state interest. That then brings us to the follow-up case for the University of Michigan Law School in the case of Grutter versus Bollinger. Given that the point system was found to be unconstitutional, the question was, can you still use race as a factor as part of the admissions process? And the court says, yes, you can. That you can look at race amongst many other factors. Academic experience, work experience, economic status, all sorts of things you can look at. Race can be one of those things because achieving racial diversity is a legitimate, compelling state interest as far as the court is concerned. So race can be one of many factors to be considered, but it cannot be the only factor that is considered, or it cannot serve as the ultimate factor being considered. So once again, it's a very narrow, tailored idea of trying to achieve the compelling interests of racial diversity in schools without being, violating the Constitution by a point system, fixed quota, whatever. Getting into the 2010s, we have the University of Texas case, Fisher v. Texas, and this focused in on Texas's top 10% policy that stipulated that if you were a graduate of a public high school in Texas and were in the top 10% graduating class, you automatically gained admission to one of the university's public colleges, one of the state's public colleges, including the University of Texas. Now, one of these applicants, Abby Fisher, is not going to get in the top 10% of her class. She was in the top 12%, and did not get the automatic admission. And therefore, she had to apply in the general pool where race, amongst many other factors, is considered. She claims that the use of a top 10% policy, given the vast disparity of the quality of public schools in Texas, was a violation of her rights, and therefore required her to compete with other students to show race as part of a factor for admissions was a violation. Well, the court once again upheld the idea of affirmative action, upheld the idea that race can be a factor amongst many others when considering admissions. And then that brings us to the current lawsuit right now regarding a number of Asian Americans suing Harvard University over their application process, claiming that Asian Americans are being disproportionately denied admissions to the university based on how Harvard University was assessing students based on a personality test in addition to academic standards. Basically, Harvard University was acknowledging that Asian American applicants were scoring, very, very high on the standardized test scores, for example, but not scoring nearly as well as other people, including Latinos, blacks, and whites, on the personality test. The lawsuit is claiming that the use of these tests is inherently racially biased and cannot be used, otherwise it's a violation of the 14th Amendment Equal Protection Clause. Right now, the court is still deciding whether or not to take the case, so it'll be interesting to see. One thing to kind of round out with these court cases, you're kind of seeing a pattern here. The court has basically said, with regards to affirmative action, it is constitutional. Seeking racial diversity in a college setting is a legitimate, compelling state interest, in order, therefore legitimizing some degree of racial distinctions being made in the application process. But note, it is very narrowly tailored. It cannot be set to a fixed quota system or a point system. And note, these rulings have gone right down, for the most part, ideological lines. These have been very, very narrowly in favor of affirmative action. 5-4, 4-3. With just the slightest of majorities. With the supermajority of conservatives in the court, it would be interesting today to see how the court might look at that. So the favored form of action is certainly in question for sure. So we'll see you next time.